always forgot which way is. There.
All right, welcome everybody to the Municipal Engagement and Agriculture session with DMR and this Maine Sea Grant. So this is basically to help the municipal officials to try to figure out if we have any questions for DMR or for the Maine Sea Grant, and to gather information. And towards the end of their presentation or their talk, the main public will have time to ask questions to them. So I ask the public to just hold your questions till the end. All right, and then I'll hand it off to Natalie with the Maine Sea Grant.
Hi, everyone. Nice to meet you all. Thanks for coming tonight. So my name is Natalie Springle. I'm with the University of Maine Sea Grant program, and I'm here to just kind of help facilitate this conversation with all of you. And I thought I would just take a minute to share a little bit of the background on how we came to have this session with you all, and then jump into the agenda. There are agendas over there if anybody wants one, and there's also this handy publication, Aquaculture in Maine Waters, which gives you overview on some of the stuff that we're going to chat about tonight. And we'll have everybody have these guys introduce themselves too. So, but first, a little bit of background. So about a year or so ago, the Department of Marine Resources approached us at Maine Sea Grant to help think through how to do some community engagement and public outreach around aquaculture on the coast of Maine, because as you all know, aquaculture has been growing in the last few years. You all know that very intimately. And so people are asking a lot of questions around what does aquaculture mean for our communities? What are the opportunities? What are the challenges? And there aren't that many opportunities for people to engage in conversation around aquaculture. And so what ends up often happening is that the questions and concerns that members of the public or communities might have end up getting sort of posed in the public hearing process, which is not a convenient place for conversation to happen, because a public hearing around a particular lease or proposal has sort of a very specific scope of what can and can't happen there. And so we've been having conversations around how can we create a process so people can talk about aquaculture and not be limited by the hearing process. And so that's kind of how we ended up in this process. We did a few of these sessions with DMR maybe 3 years ago during the first few months of the pandemic, 2 years ago, whenever that all was. Pandemic's kind of a blur. And at that point, we did them online because the world was online, and they were sort of general public sessions. But one of the things that both the folks at the DMR and us at Sea Grant really recognized through these public sessions, we did 3 or 4 of them, kind of spread up and down the coast, but they were open for the general public. One of the things that we really kind of heard was a need was that the process of aquaculture and how a lease can happen in communities can sometimes be really confusing for municipalities specifically. So whether it's select boards or members of committees, harbor committee, or whatever your various towns have, or, you know, with turnover in committees and elected officials that sometimes change, it can be a place where there's confusion around, well, what's the role of the municipality? Where does a municipality tap in? So we identified that as like something that would be useful for municipalities to have a little bit of opportunity to engage with DMR around what the role is. And so from there, basically that's sort of the background of like the larger, bigger picture. So why Shabig? Shabig is the first one of these sessions. We don't know what's going to come of them in the future, but we figured let's start with Shabig. And why Shabig? some ones or twos or threes of you, I don't know who, apparently before the pandemic approached the DMR and said, hey, can you guys come out and talk to us? So I don't know who that was, but that doesn't really matter because DMR said, sure, and let's have Sea Grant help us out. And so that's kind of how we ended up here in Chablis. And also because you guys have stuff going on with aquaculture and it seemed like a good place to start this conversation. So that's a little bit of the background of how we're here tonight. And then as far as the goals of this particular session, they're on the agenda, but basically it's targeted for those of you in the room who are municipal officials in some capacity to gain a better understanding of aquaculture and the process of where municipalities can connect to the process, the regulatory process, and then also have a give and take, have a conversation. So questions that you guys may have, concerns, really an opportunity for two-way conversation and for listening. And so we're going to start with having Amanda in a couple minutes, just kind of give an overview of the regulatory process so that everybody has the same kind of baseline information. And then that's it. That's all we're going to do. That's official, because then we're just going to open it up to conversation with all of you to talk about whatever the questions are that you have in mind and comments and questions. And before we jump in, maybe we can have the Sea Grant and DMR team introduce ourselves. So I introduced myself, Amanda.
Yeah. I am Amanda Ellis. I'm currently the acting director of the aquaculture division. Although I wear a bunch of different hats for the department, so I recognize some faces from my prior role as being a hearings officer for lease proceedings on Chablis, but also special licenses and rulemaking for the department as well.
Cole Cameron, I also work for the Department of Marine Resources. I'm the director of the Bureau of Public Health. So prior to a few weeks ago, my main responsibility was dealing with shellfish sanitation issues. But aquaculture, the aquaculture division is going to come under the umbrella of our bureau, so I'll be more involved in aquaculture going forward.
Thanks.
Thanks. Hi, everybody. My name is Dana Morse. I'm with the Maine Sea Grant Program and Maine Cooperative Extension. I'm based out of the Darling Marine Center. Most of my work these days is in shellfish production. So how to grow oysters, clams, mussels, scallops, that kind of stuff. So I end up working with producers around the state on technical assistance or applied research or educational programs. My role here mostly this evening is if you've got a question about some kind of shellfish production or a little bit of seaweed, kind of the details around that, hopefully I can be of service in that regard. My background's in fishing gear design, but I haven't been involved in that part for a little while. But just something to know, I guess. Thanks.
Hey everyone, my name is Megan. I work for Maine Sea Grant and Extension with Dana and Natalie. And my background is in research and shellfish, especially raising seed in a hatchery. And my role tonight is mostly to take notes. So that's what I'm here doing.
All right. Anyone have any questions or thoughts about the process? Yeah.
Sorry, my apologies. I didn't say this
Yeah.
when I was up here. If you guys want to ask a question, please come up here to the podium or step a little closer to the owl. We try not to go that way because there's a lot of wires, but basically so the owl can pick you up, which is the electronics. Thank you.
Thanks. All right.
Well, thank you, everybody. It's great to be here and talk more about how municipalities can participate in the leasing process. Cole is passing out a document that department staff put together. And in case there's anybody participating online, it's my understanding that this is going to be posted online. This document is also available on our website as well under our, you go to our aquaculture page under public participation. But what this document is the leasing process itself. There are a variety of different laws and rules process-wise that govern how proposals are evaluated and whatnot as they get carried through the process. Some of that comes from the Maine Administrative Procedures Act. Some of it comes from rules and laws under DMR's jurisdiction. So what this document is staff kind of pulled out those discrete steps in the leasing process, and that's what this is outlining. This is specific to standard leases. We also developed a document, another what we call a process flow chart for experimental leases and LPAs. Tonight, I'm going to go through the standard process rather than kind of having you look at two different documents. The processes are relatively similar, but what I'll do tonight is I will intentionally try to call out where they differ. And I'll also try to call attention to the discrete steps on this document that involve the municipality. So if you wanted to take notes on this or mark otherwise where a municipality would be involved, I would encourage you to do that. I'm going to be focusing on municipal participation in the leasing process. So leases include experimental leases, which are can be up to 4 acres in size, and they can exceed a 3-year term. And then standard leases, which are can be up to 100 acres in size and can be held for up to a 20-year term. The aquaculture program also processes limited purpose aquaculture licenses, what we shorthand as LPAs. Those are annual licenses that expire December 31st of each year, and they're very limited in scale. They've kind of been likened to like a permit by rule process, and so the process varies a bit with those, and there's a lot of ground to cover, so I'm gonna just kind of intentionally focus on leasing for the purposes of this evening. I will try, because the process touches a lot of administrative law, I will try not to use that jargon and be clear and concise in explaining things. But if I start referencing terminology that you're not familiar with, that you'd like me to explain, just let me know. I'm happy to provide clarification. And before I begin, I would just like to kind of ground us in what aquaculture currently looks like in Chesapeake waters. So by my count, there are currently 8 active leases in Chesapeake waters. Some of those overlap in Long Island waters. 4 of those are standard leases, 4 are experimentals. There are also currently some pending applications before the department, which means they're not currently active leases, so they haven't been granted, but they're in some phase of this process here on this form. There are 2 standard leases pending and 2 experimentals pending, and I believe some of the standards that are currently pending are actually existing experimentals that are being converted to standard leases. So for example, if an experimental lease is held for commercial purposes, at the end of that 3-year term, someone could apply if they wanted to convert it to a standard lease. So that sort of just gives us a general kind of jumping off point of what aquaculture looks like in Chesapeake waters currently. With limited exception, the state has exclusive jurisdiction to lease Maine's coastal waters and portions of the intertidal zone. However, rule and law really recognize the importance of municipal feedback in the process, and there are many opportunities for towns to engage in leasing. I did say, with limited exception, the state's authority is exclusive, but municipalities do have limited jurisdiction in the intertidal zone if they have an approved shellfish program in accordance with 12 MRSA 6671. So basically, if you have an approved program with DMR, a municipality would have limited jurisdiction there. Chesapeake does have such a program. So functionally, what this means is if an applicant came in and applied for a site in the intertidal zone, the municipal officials would need to consent to that site. I want to point out that it's the municipal officials that need to consent to it, not the Shellfish Committee itself. That's a distinction sometimes that often I think applicants sometimes get confused, so they'll apply to us and they'll say, it's in the intertidal zone, the Shellfish Committee approved it. We have to go back and say, no, 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 it's actually the municipality that needs to sign off on it. We always encourage applicants to talk with shellfish harvesters, to talk with their shellfish program beforehand though. So even though the permission piece falls to the municipal officials, you know, we're encouraging those conversations to happen early with the Shellfish Committee as well. I also want to highlight that, you know, law and rule provide the municipality with additional opportunities to provide feedback when compared to other stakeholders that may engage with the leasing process. So that's built in to the process here. So one of those is, for example, before an applicant can submit a draft standard lease application, they are required to hold a pre-application meeting with the municipality and department staff. And the purpose of this initial meeting is for the applicant to present their proposed plan to the municipality and DMR. And you know, the intent there is for DMR and the municipality to let the applicant know, to provide them with feedback about what they're intending to do before they actually put kind of pen to paper and submit a draft application. You'll note that this is listed as the first process here on this flow chart. Typically, when you say the meeting is scheduled with the municipality, it's usually with the harbor master. But if the harbor master is unavailable for whatever reason, usually another municipal official will attend in that capacity. After the pre-application meeting, the applicant then submits a draft application to DMR, which, as it sounds, it's sort of a tentative plan that details their proposed operations. We review that application to make sure that it contains the requisite information. And when we feel that it has all the necessary information, we deem it complete, and then the applicant is responsible for scheduling that meeting. The scoping session is led by the applicant. We call it the applicant's meeting. DMR staff typically don't attend, but the notice of the scoping session is processed by the agency, and it's a meeting that's open to all stakeholders to attend. So that's when, you know, members of the public come, any municipal officials can attend as well. And it's another opportunity for the municipality to provide feedback. And this is sort of the third box on the flow chart here. It comes after the draft application. The difference between the pre-application and scoping phase is really in my mind, is the level of public participation and the fact that there's now a tangible proposal in play. So, for example, as I talked about, the pre-application meeting is geared towards the municipality, but there isn't a draft proposal yet. At the scoping phase, there is a draft proposal, and that meeting then starts to pull in other stakeholders that are interested in learning more about the proposal. We always encourage the municipality, and especially the municipality, because I'll focus it here, but to provide feedback during those pre-application phases, so the meeting and the scoping session. This is because the applicant is still, you know, planning on what they're doing, right? Nothing has been finalized, no application has been deemed complete, so there's still a lot of fluidity in the planning. After the scoping session, the applicant then submits a final lease proposal to us, which is reviewed and then deemed complete. After that final application is deemed complete, it gets noticed by us. And that means that we are sending the municipality direct notice that, hey, a final application has been deemed complete, and we tell the municipality where they can access a copy of it. We're also sending the municipality a harbor master questionnaire to complete. I often get asked, where does that requirement come from? Why are you sending us a questionnaire? And that comes from statute. And what that questionnaire is intending to do is it is asking the municipality, in consideration of our leasing decision criteria, to provide their feedback and observations about how the final lease proposal may impact things that we can legally consider as part of our decision criteria. And some of those decision criteria include things like navigation, commercial fishing, recreational activities, and that sort of thing. It's optional to provide, to send it back to us. It's not something that you won't, once we send it back, it's not like they have to send it back to us, but it is highly encouraged because it gives us a lot of great feedback that we then can consider when we're doing our site assessments and whatnot. I did want to point out there is no public comment for standard leases, as they're going to automatically go to a public hearing. And then, as I mentioned, you know, I talked a little bit about this. There is some variability in the steps for a standard lease versus an experimental lease. And one of those key differences is experimental leases don't have any pre-application requirements. So if someone is submitting an experimental lease, they don't do pre-application meetings and they don't do scoping sessions. They apply directly to us. It's kind of akin to someone who's submitting a final standard lease, right? So that application, an experimental application, comes into us. We review those proposals as they're submitted. And then when those proposals are deemed complete, the municipality is again sent notice that we've received an experimental application, it's been deemed complete. They're also again sent the harbor master questionnaire. But the difference is that with the experimental, that notice is going to tell the municipality that there's a 30-day comment window within which you can submit comments to us, or if the municipality would like, they can request a public hearing on the application. Experimental leases, public hearings are optional or at the department's discretion, unless we receive 5 or more written comments during the comment period. So that's where you see some variability there between those two processes. After any application is deemed complete, whether it's experimental or standard, DMR scientists visit the proposed site and they're conducting the site assessment. And their site, when they do these site assessments, they're doing it through the lens of the decision criteria. So they're going to evaluate things like, you know, what navigation activities they're observing in the area, commercial fishing, that sort of thing. They're also taking different measurements and what have you, as required in regulation as well. And what happens is after that site assessment, a site report is published. And the site report is going to include any findings and observations that were made by science staff. Copies of the site report are posted online and they're made available at least 30 days prior to any hearing if one is held. And then if a public hearing is required, so like I said, automatically required all the time for standard leases, experimentals, it's at our discretion unless we receive 5 or more requests. We provide the municipality with notice of that public hearing. And that the notice of the public hearing is going to include things like, you know, the date and time of the hearing, any registration requirements. And that hearing notice is also going to include instructions on how to request intervener status. And if you are kind of following along on the flow chart here, we're at the public hearing, which comes after the site report. Sorry about that, should have called that out earlier. So intervener status, we do get some questions about this, and we're often, you know, like trying to explain what it is. An intervener is a legal party to the proceeding. And generally that status means that, you know, the entity or person who was granted intervener status has the opportunity to present witnesses during a public hearing, and they have the opportunity to submit comments on the proposed decision. A municipality doesn't need to be an intervener to participate in a hearing. DMR rules do provide a carve out, so municipal officials may provide testimony about the proposal, and their testimony is separated out from members of the public who may have registered to participate and also provide testimony. However, if a municipality ever wanted to intervene in a proceeding, they don't need to apply. So you don't have to submit an application. Our laws provide that all the municipality needs to do is request to us in writing, we want to be an intervener, and we have to automatically confer that status. I point that out because for anybody else, any other stakeholder, they actually have to apply to us to be an intervener. We review that application, and then we have to make a finding whether or not they would be granted, they should be granted intervener status. Municipalities, another thing that kind of comes up in cases like this is municipalities that intervene in a proceeding have discretion on who they designate to participate on their behalf. For example, our laws don't expressly require that a town attorney or a specific municipal official participate as an intervener. However, those are things that a town might want to consider prior to submitting a request. As you might have your own considerations about, as a municipality, if we participate as an intervener, who's going to be representing us in that proceeding and on our behalf. And there may even be considerations, I'm not sure, but just am highlighting this for municipalities, there may be considerations too about whether or not you elect to retain counsel to represent the municipality throughout the course of that proceeding. In some of the proceedings too, DMR issues procedural orders. Not all the time, it just depends on kind of the nature of the case and the complexity of the issues raised. If we do issue a procedural order, that's a document that governs the conduct of the hearing. An easy way for me to think about it is I kind of think about it as like a playbook almost, where we're saying to all the parties, this is what you need to do in order to effectively participate or engage in the process beyond what our current regulations would contemplate. So to give you an example of this, a procedural order might say to everybody who's participating, DMR would request that you pre-file anything you want to consider as an exhibit ahead of time. Those are those things that might be included in a procedural order. They might also specify things like testimony time limits and that sort of thing. Although again, not always the case. Depends a lot on the context. After a hearing, what happens is, the department at the hearing is taking evidence and testimony that's related to the decision criteria that we can legally consider. I talked about some of those criteria earlier, and they are posted online as well. But after the hearing, we've kind of taken in all of that evidence. We're going to eventually we'll issue a final decision on the proposal. If a municipality was an intervener in a proceeding, they'd have the opportunity to review and comment on the proposed decision prior to it being finalized. But after a final decision is issued, DMR always sends notice to the municipality, letting them know that we've issued a site in your community. And that notice outlines the municipality's right to appeal the decision as well. So if a municipality elected to appeal a lease decision, those appeals are handled separately by the court. They move into the court system. It's not done internally at DMR. So an appeal would go to Superior Court. I like to point that out because sometimes people are used to other administrative agencies that are set up differently, that have a board that would maybe review an appeal, but in this case, it goes directly to the court. So those are all the ways that a municipality can participate in the process. It's just a general overview, but with that, I'll turn it back over to Seagrant to help facilitate the Q&A. Thank you.
Yeah, thanks, Amanda. So at this point, we just want to open it up to whatever questions, comments, concerns you all may have regarding anything that Amanda shared. If you have any clarifying questions or things you will kind of want to hear again, so it was a lot of really good but really heady information. Or, just kind of opening it up for a general conversation. And it would be great if folks who are connected to the town will start with you all, and then a little bit later we'll have kind of more open public comments, right? It sounds like. And then you talk to maybe if anybody has questions or comments, you should pop up so that the owl captures your voice so that it can be broadcast. Yeah.
John, well, how that's what she needs. Other questions?
I think we need to have you come up because they're recording for folks. Thank you.
I have a question on who does the site evaluation and who determines what time of year you go, because this makes a huge difference.
Yeah, yep,
And it seems that the ones that have been done around here are done in real late fall and winter time where you don't see anything, you know, and we'll say there's gear there at certain times of year, then the person who's applying will say there's nothing there because you went out and did a site evaluation, you saw one buoy maybe, and that was it. So I was wondering, you know, it's a long process, so why couldn't you make it a couple site evaluations, one in the busy time and one in the not so busy time? So,
Were people able to hear the question? Yeah, okay, great. Thank you.
thank you for your question, and there are a couple parts there that stuck out to me, and I'll try to address all of them. So site reports are, site assessments are conducted by DMR scientists at a time of year that's conducive to evaluate the proposed operations. There's some variability in operations. So for example, if an applicant is proposing to grow marine algae, that's usually a winter crop. That's when that application would be, or that proposed site would be most active. But we do try to take into account as well, like the seasonality of the operations and that sort of thing when we are determining to do site assessments. There is, you know, within this process itself, I would point out that, you know, an applicant is putting together a proposal that's based on their observations of the area. Sometimes I think when an applicant submits a proposal, there's an assumption that, you know, what they're saying is what is, you know, the truth writ large, but it's based on their observations, right? And what the process does here and what it allows for is, and we recognize too, our site assessments are a snapshot in time. You know, if you go out and visit something one day, you might see boats, another day you may not. That's why the process, though, in and of itself provides so much opportunity for feedback to build that holistic record around what is happening here. And it's why I think the municipality's feedback is so important. And there's why there's so many options to do that, to participate in a public hearing, to participate in a pre-application meeting, to participate in a scoping session, because it, you know, it is possible an applicant may not have observed something that you're familiar with as a municipality, or whatnot, or maybe uses that we didn't encounter when we were out doing our site assessment.
I think I heard part two of the question maybe was, is there a way to do more than one site assessment or come a couple times a year?
well, you know, the person that's putting in the application is gonna say there's nothing there. You know, and then somebody on the island's gonna say, you know, there's stuff there, it's not here. And you might not see, you know, there might be a solid dredge that goes by that area, you'll never see it because it only happens once in a while. It's things like that that I think that need to be addressed.
And I think, I mean, you know, to your point, an applicant may document something in their application based on their observations. A municipality may see something that doesn't align with that, but that would be an important thing to share with us through the process.
A lot of times I've asked before, I've sent emails out asking when they're gonna go and look around. I never get anything back. I'd like to go with them and they go out. And I never got a response when, you know, when people go to the site.
Thank you. That's good. That is good feedback. I mean, and we do, you know, in fairness to all applicants and an efficiency of resources, we do schedule those based on science staff availability and in consideration of the proposed operations and whatnot, but that's good feedback. I appreciate you sharing that.
What about the federal district court now, whatever? Let's say a site gets issued.
Could we have you just kind of sneak up to here?
Is that the
Just a little closer.
I mean, anyway, So let's say a site gets put in and turns out to be in a bad place, then does the DMR have the power to just move it or not?
So, and a couple things there, are you talking about like in terms of an appeal or
I'm
just
just
kind of?
saying, I mean, we've had one where it turned into be in a bad place and kind of agreed to move it, and it's moved. But you guys, it shouldn't have to go to federal court to have a bad site that gets approved and gets determined to be a bad site. It shouldn't go to federal court. What the hell do they know about what goes on in the waters? I mean, it should stay in the people that know what's going on's hands to correct the situation.
Yeah, I can, there are a couple things there. Just to clarify, if a final decision is appealed, and so, a final decision for us is what the commissioner signs off on, that's the final agency action, and the municipality gets notice of that. If the municipality or anybody else wanted to appeal the final decision, they would go to Superior Court, which is in Maine. It doesn't turn over to the federal court system. I just wanted to clarify that. And then it kind of it works its way, that appeal would work its way through the court system. And depending upon the issues at play, the court may remand that to us and whatnot. So there's a variety of different ways that those types of appeals would pan out. But to your point of, if I'm understanding correctly, what are the options if a proposal is cited in an area that is, that may interfere with the legal criteria that we have to consider? It depends on how far along the applicant is within the process. If we get to a public hearing and the municipality or others are saying this site should be moved, at that point, it can't be moved because it's been noticed, it's gone through the process, it's kind of we're evaluating it as it is. So, what could potentially happen, there are all kinds of different scenarios, but ideally, when you get to the public hearing phase, we hopefully, because of all the pre-application steps and the opportunity for feedback, I would hope it wouldn't be a citing issue at that point, but you can certainly provide feedback on that, and then an applicant may elect to, after a public hearing, they could withdraw the proposal. If they withdraw the proposal, they would then need to reapply, go through the process again. It's entirely possible based on the evidence and testimony and whatnot, if we made a finding that it was going to unreasonably interfere with something, then it would be denied, and that sort of thing. So there's a variety of ways that could kind of play out. But we would hope, if process-wise, that those concerns are addressed at the very beginning of the kind of review process.
Yeah, there ought to be a loophole for if they're not, or everything's a learning curve, and I think we've discovered that sometimes they get granted, and everybody thinks that A to B is the road, but everybody's going somewhere else, and it turns into some of them get right.
So here and then in the way back.
I'd like to first begin what I have to say by saying that I have nothing against anyone who wants to have an agricultural lease. What I have problems with is the process and the legalities of it. And if anyone of you people who are here promoting agriculture, the way I see it, if you would care to come with me on my boat, I can show you 5 different places that I can no longer fish my traps. And I was never asked by anyone if their oyster leases would interfere with my fishing there. I've been fishing for 79 years. If I live till 69 years, if I live till May, I'll be 80 years old. And I think that I have seen enough stuff come and go, so I deserve the right to speak on what I have to say about the process. One thing you said in your spiel that wasn't true. During the pre-hearing lease, the applicant shows up and tells us what his plans are. DMR isn't there anymore. I was at one right here in this very hall. where the applicant was the only one here, DMR was not here. That, have problems with that. DMR is supposed to be regulating stuff and supposed to see that it's true. I honestly would like to have every Boston in this room understand the way I feel about it. I honestly feel that the process of leasing is changing what has been commonly public domain into private property. When you give out a lease on what has been used as the operative words, as public domain, the right of everyone who has a lobster license, a fishing license, or whatever license to use that to go fishing. They have that right. When you give out a lease to that area, then you've changed the whole aspect of our culture, our fishing culture, which is supposedly what we're going to pass on to our kids around here. It's totally wrong. I feel very strongly about this whole process. I feel strongly that leases can be sold. They should not be sold. They can be sold without a hearing. You establish a lease, you don't want it anymore. The commissioner says you've done substantial agriculture, so it's a legal lease and it's all legal. You don't want it anymore, or you're a developer. Maybe you just want to sell it and make some money. So somebody comes along and buys it. They can be somebody from Canada. They can be somebody from China. They can be from anywhere in the world and come here and take waters away that we have considered and used as public domain. The whole process has to be changed. Process of selling it leaves a lot to be desired, and I think it's actually illegal. You give out a lease for a kelp applicator. The person wants to grow kelp, and they say it's great because it is good in a way, because it takes away the material that's there to grow the kelp on is gone during the period of time when the lobsters are around. But what they don't tell you is they don't move the moorings. That precludes any kind of drift fishery that might want to happen there. I always used to take and set my mackerel nets out in the spring out here and drift them down the shore. I'm not gonna be able to do that. I have to come to these meetings. It's imperative for me to come to these meetings and try in what limited way I have to express myself about all the things that I could go on for days about what's wrong with the process, not what's wrong with the people or not what's wrong with their need to do it. And I can understand people, fishermen can see lots of fishery is going to be gone in a few years. They want to do something to stay on the water. I fully understand that. And I'm almost 80 years old, and I don't go to lease hearings anymore because I decided that I'm going to bite my tongue and let these young people make their own mistakes. And as far as I'm concerned, all the people here who are promoting aquaculture, that's the way I see it. What I see you as enablers in something that is the process is wrong. And I'm not saying that you're bad people. I'm just saying the process is wrong. And we go and try to promote a change in some of the aquaculture laws. And every person in this state that belongs to some kind of a group that has to do with making money and promoting aquaculture comes and fights just as hard as they possibly can. And what it ends up doing is changing the process, and it makes it unfair, makes it even more unfair because we have no access. You talk about going to court. why the hell should we have to go to court to keep doing what we've always done, and we pay a license fee every year to do? Why should we have to do that? I could go on for days, and I'll shut my mouth because I'm old and that, and probably a lot of people here hate me. But that's the way it is. That's the way I see it.
I appreciate your feedback, and, you know, I did just want to react and kind of clarify a few things for some members of the public based on what you had shared and what your observations are. In terms of, you know, taking some notes, and in terms of scoping sessions, those are the applicant's meeting. DMR usually does not attend those because it's an opportunity for the applicant to hold an informal public meeting on their proposal. The other thing too about the leases being sold, there is a process for lease transfers. So a standard lease only, a current holder could apply to transfer that lease to someone else. It goes through a public process. It goes through a review.
Is there a lease hearing?
There is not. Lease transfers are not an adjudicatory proceeding. But what happens with the transfer is it's a change in holder. It's a change in holder only. It's not a, if the transfer is granted, the new holder is subject to all of the same conditions and you know, operating procedures as what was initially granted. And there is a public comment period on those, but I just wanted to clarify. I know there's a lot of kind of nuance here with the process. The state is not selling aquaculture leases. A holder could apply to it for a transfer. And then the point about, you know, we shouldn't have to file an appeal. And I just want to clarify that's not what I was saying. I was kind of walking through the different steps in the leasing process and pointing out that a municipality or other stakeholders would have the right to appeal a final decision. I think ideally what would happen through the process is the municipality or other stakeholders are providing feedback to the department at the appropriate times, at the correct times, and we're taking that consideration in and evaluating it in consideration of the legal criteria that we can consider. Unfortunately, sometimes what happens is, you know, to Natalie's point, which was, I think, kind of why this conversation came to fruition, is sometimes we'll have a lease hearing and people will turn out and they want to talk about the process and that they don't, you know, maybe they have concerns about aquaculture, and that's not the place to have those conversations. The purpose of the lease hearing itself is to get feedback, evidence, and testimony on the specific proposal as it relates to the decision criteria. And there are specific times that has to happen for us to get that feedback and for us to be able to consider something. So I guess the message here is I would encourage anybody who has a specific concern about an aquaculture lease proposal that relates to the decision criteria to get that on the record at either a public hearing or if it's an experimental lease, to provide that feedback to us at a public comment period or request a public hearing. Those are the appropriate channels to provide that feedback.
I've been to, I couldn't tell you how many, and I've seen 2 leases denied. All the rest of them were granted. I've seen experimental leases all of a sudden turn with a dozen oyster boxes. All of a sudden, the next year, there's 100. Then there's 400. And in places, once again, I will offer any of you that want to go in my boat, I'll take you out and I'll show you 5 different places that I no longer can fish my traps. No one asked me whether I fished there. No one even cared whether I fished there or not. I pay a license fee for my lobster license, the state of Maine, and have for a good number of years. And I deserve to have the right to fish there without having to worry about getting snarled up in somebody's oyster boxes. I've taken traps in fall to these, couple of these places and dried them out overnight in the boat and take them there in October when there should be some lobsters there in the eelgrass and turn around and come back because I could not set my traps where I used to fish. And I'll tell you, it's damn infuriating. No, you wonder why I get upset and mad about what is happening in this state. It's beyond me. With the stuff that's going on with the windmills, with the stuff that's going on with the whales, with last summer's lobster debacle, which was, none of us made any money like the year before.
Ernie. Gotta allow other people.
I will. I'll shut up.
Thank you.
But
Thank
once
you.
again, any of you want to go, you want to see firsthand, you come with me on my boat and I will show you those leases strung right across from one island to another island where I used to fish. I no longer can fish there.
Thanks for sharing your perspective. And the one point that I wanted to make, and then I think Dana wanted to say something as well, is Amanda talked about how the hearing process is a difficult time to hear some of these concerns, which is exactly why we're here
They
tonight.
don't
So your
allow you to
concerns
express your
are
feelings
welcome.
to the hearing process.
Yeah, the hearing process,
It's all legal stuff.
right.
And that is, you know, we are working on setting clear expectations for members of the public around that, because that's what these hearings are about, the specific proposal at hand, not sort of aquaculture, other considerations related to
Exactly.
aquaculture.
That's what I'm telling you. And that's why I had so much to say here tonight, because I thought there might have been an opportunity to express some of my opinions about what the hell's going on
Yeah.
and
Yeah.
how many aquaculture leases there are going on in this area. This is the epicenter of it, what's going on here, all the oyster boxes. I mean, it's
So,
it's
sir,
ridiculous.
if I could interrupt you, just because we don't have a
Oh,
huge
sorry.
amount of time, your comments are absolutely valid and
I could
welcome.
go
I
on
just
for
want to
a
make sure
month.
other people.
I
have a
could talk to
chance
you
too.
people for a month. and
So,
I can do one
Dana,
day.
you wanted to say something and then I think Gennaro, is that your name?
Yeah, a quick feedback, and I should have said this at my introduction. I've been at the Maine Sea Grant program for almost 25 years now. I'm also a leaseholder. So my oyster farm is in the New Meadows River. I've grown oysters since 2014. So just so you know who you're talking with here. So your point, if I understand, Ernie, is like, how do you make this change? Like, how do you get things to change on lease process and all the things around leasing and ownership and transferability? Kick me back into bounds if I'm wrong here, but the department is operating on what the legislature gives them.
That's right.
So
It's all legal.
yeah, so really to get right to the point of your question is, how do you change this? You got to work on the legislature.
Exactly.
And the one thing, and so that's a difficult, but it's a clear task. And the other thing that I'll add is, and this is just by way of like historical perspective, in about 1759 was the first years that the state of Maine put in some provisions through the legislature, I think, to protect seeded oysters. And this was, I think, in the Sheepshead area. So we didn't have leasing, we didn't have any of the regulatory stuff that we had. But back then, a couple of 100 years ago, people were thinking about the question of, geez, you know, I'd really like to put some oysters on the bottom because there's a good market for them, but I want some protection so that they don't get drug up or harvested, and I have some protection for those oysters. So that same question goes back a couple of 100 years, and then over time, the legislature adopted the leasing statutes in about 1973, I think it was. So the thing that you want to change is definitely a political legislative engagement process if you want to go down that road.
It doesn't work. I've been
Fair
to
enough.
many here.
I won't argue with that. I'm just pointing it out that to make change in this leasing process is definitely going to involve the political aspect of it. That's all.
Can I just say that the change has already been made? And then, what year did you say it was, 1759?
About
I think
1759.
that was the same year I started law.
Yeah, my years might be,
Let's
my
go
years
in the
might be.
back over
I
here.
just wanted to add to Alex's comment about the leaf from the way.
Yeah.
That was issued in another town. So it kind of circumvented us. It was in the town of Yarmouth, which it looks like it's on Shabby, because it's closer to Shabby, but it's in the town of Yarmouth, so that's what we were talking about.
Okay, thank you.
So that kind of touches on my question. Here around Shabig, the waters are really close to other towns, and Yarmouth's like right there. So how come the process doesn't invite multiple harbor masters that are close to the towns? Because Yarmouth might say, there's nothing really there, nothing going on there, but the Shabig one's like, yeah, this is going on there. Or because Yarmouth doesn't follow what we're doing, and then we don't follow what Yarmouth's doing. So, or I'm just using Yarmouth as an example. There's other multiple towns like Long, Portland. So it touch everybody, and so just curious.
Yeah.
Sure. So a couple things there. One is, the leasing process itself is very notice driven. And the law tells and outlines, says DMR, you need to notify the municipality where the proposed site is located about this. So, but my point there is, well, we may not get direct notice of a site that's in a different municipality, there's nothing precluding Shabig from otherwise participating in that process, in that process for a site in another community. If you felt so inclined to, hey, we want to submit comments on this proposal that's in a different municipality because it is affecting us or whatnot. It just means you wouldn't get direct notice of it, but you can still participate in that process.
I understand that, but say like, I'm just gonna use the one that's over here in the cove that we probably talked about. Is there saying like within 100 feet of the site or 500 feet from the site? Is there a way to change that to that? So that way, anybody that owns land or owns the water in the 500 feet from the site gets notified.
Yeah.
So the town of Shabig would have gotten notified, and we would have been through the process with the town of Yarmouth, instead of just having Yarmouth, and then we can go in and speak at a later date.
Yeah, yep. So I believe what you're talking about is that in terms of the notice requirements, the radius that you mentioned is specific. So like an LPA application, for example, actually, I'll keep it simple. I'll stick with leases only. So a lease, okay, we have to notify the owners of shorefront land within 1,000 feet of that proposal. The law says to us, we just notify the municipality where that site is located. That radius that you're thinking of doesn't apply, like, okay, it cuts into another town, because it is possible, right? That you may have parcels within 1,000 feet that are in different towns, but because the site itself sits solely in like Shabby or Yarmouth waters, you wouldn't necessarily get notice of that. But what we do as an agency is, and I'm not sure if folks are aware of this, but we do send notices out via Gov delivery, and we do processing notices. And through that platform, we break them out by town. So you could sign up to get those notices. And if you're not sure how to subscribe to that, there's you can certainly contact me if you're having problems signing up for that. But at the bottom of our page, bottom of our website, there's a red envelope that says like sign up for updates. You can sign up there, and you'll start getting notices of aquaculture proposals that are in other communities. And like I said, the notice requirements set out one thing, but it's not limiting in anybody's way, in anyone's, it's not otherwise limiting any other municipality's ability to participate in a proceeding.
Can I just ask quickly a clarification? So if if the proposal is in Yarmouth, you are required to tell Yarmouth. You're not required to tell Shabik, but if there's a landowner that's within 100 feet, the private landowner will get notified, but the town won't necessarily.
Right, and it's within 1,000 feet.
It's 1,000
It's
feet.
1,000 feet, sorry.
And,
So
and-
you don't get notified. It was an experimental lease. So it wouldn't make through without us knowing about it. This was like
Right.
4 years ago, 3 years ago, when you guys are more on top of things now, but cracks out.
And I will point out, though, if the law, the way that the law is constructed notice wise is, and which is the case, there are some proposals in Shabik that are also in Long Island waters. So if that's the case where the site sits in 2 municipalities, at that point, both would get notice.
Can I ask a stupid question? I'd like to know why it is that, given all this time and all of this, these whale proposals and all of the stuff, the hoops that we've had to jump through to protect whales, I'd like to know why it is the DMR has not moved to make everyone who has buoy lines in the water and gear in the water have breakaways and have color codes to identify their gear. Why are we, lobstermen, the only ones that have to go through all of this crap? When you can set up a kelp farm up here and there's no, my knowledge, there's no breakaways, there's no color codes on them to identify the gear. Why is it you discriminate against lobstermen and letting aquaculture get away scot-free? What about the oyster boxes, all of that stuff? I'm not saying it's gonna happen, but if I set traps up behind little motors or up to Blaine's Island, I have to have color codes, I have to have breakaways and stuff on my gear. But yet, the people that have their oyster leases and people that have kelp leases other places don't have to have that. Why are you discriminating against lobstermen?
Well, I would preface this by saying this is sort of outside my scope of knowledge and kind of topic jurisdiction, but my understanding is that a lot of those requirements that you're talking about that are specific to the lobster industry are coming from the Cole, maybe jump in here too, if you are coming from the federal government, and the state is implementing them. The federal government hasn't elected yet to speak to other gear that may be in the water. So that's, I think, where that's coming from. It's not that the state itself is electing to target any specific group.
Interesting.
Vika Wood, I'm the town administrator. I'd like to get back to the process of the municipal engagement part about this. Can you touch base on what the municipalities can do to better inform the public? Because there's, there's the pre-application scoping session, the harbor master's involved with it. I think the municipality could definitely do better to involve the community. So then people that know the waters best can come and participate. So can you touch base on what kind of recommendations you can provide for that?
Yeah, I think that's a great question, and I'll preface it by saying municipalities have broad discretion in how they want to engage with the process and how they communicate information to the folks within their community. I have seen in the past, some municipalities might elect to post the upcoming hearing on their website. They might discuss it at a town meeting. They might put, flyers out around town. There's the DMR is holding a hearing on the proposal, that sort of thing. I've seen a variety of lots of different ways. I think from what I've seen, it's probably specific to the community. The municipality probably knows the best way to reach its citizens if they want to encourage them to come out to a hearing. The state rule and law isn't saying to the municipality, this is how you have to do that. You have broad discretion in how you get the word out.
And at the scoping stage is another place where the municipality could encourage people to attend the meeting that's being held by the applicant.
Yeah, and that's a good point. I think one thing that we, you would just want to clarify is, anytime you're encouraging participation, encouraging it in line with the process, right? So if you're getting a notice that says, hey, DMR is an experimental lease, it's been deemed complete, DMR is accepting comments, this is the deadline to submit comments, you would probably want to reiterate that instead of saying, hey, we're going to develop our own separate comment process outside of this and try to submit comments to DMR on this outside of that process, because we're limited in our ability to consider things outside of those procedural windows.
Why did the scoping sessions change? It always used to be when they had a scoping session, the applicant would be there and then DMR people would be there to explain some of these technicalities and these laws and stuff.
Yeah.
And all the hoops that we have to jump through. So why did they change it? And now the last one I went to, the only one that was there was me and the applicant.
Yep. Yeah.
Why did they change it?
So I believe that used to be a regulatory requirement, and my understanding for the basis of the change was it was really, those were really intended to be the applicant's meeting. Those meetings don't determine the final outcome of the proposal or anything. It's really the opportunity for the applicant to say, that these are my proposed plans. And what used to happen, actually, I'll back up now that I've got me thinking about this more, is a while ago, so this is prior to 2019, an applicant never had to submit a draft application. What they would do is they would do a pre-application meeting, and then they would go to a scoping session. And what was happening was at the scoping session is the applicant would come, but they wouldn't really have anything, they wouldn't have much tangible things to present. So what happened was the law change that occurred in 2019 required an applicant to submit a draft proposal ahead of time. So every stakeholder would have something tangible to review and to provide feedback on. And I think in acknowledgement of that and the fact that it is really intended to be the applicant's meeting, DMR doesn't staff those. And doesn't attend those. But again, they don't determine the outcome of the proposal. It's just another opportunity for a stakeholder to provide feedback prior to an applicant submitting a final application. Let's go right here.
Yeah, I have two separate questions. One is there a timeline on any of this process? And if there's not, should there be? And then the next question, you mentioned if we have the shellfish ordinance in place, we have jurisdiction in the intertidal zone.
Mm-hmm.
Just curious if we have any out of the intertidal zone, and if that has to do with the home rule that.
Sure. So your first question is, are there, and if I'm understanding correctly, did you mean, are there timelines like around application submission?
Yeah, how long should this process take, and is there any deadlines for what you folks do or what
Yep.
applicant should do?
Yep, okay. So in terms of timelines I'll start with kind of application submission. There are no application submission timelines imposed for experimental leases. There are for standards. So once an applicant elects, and the timelines really are around the application submission and our turnaround time in turn to those submissions. So for example, I'll just give you, once a pre-application meeting happens, the applicant has 120 days to get us a draft application. And our obligation here is we try to turn them around within 30 days. Any of those revisions and whatnot. And then in terms of, there are some other kind of timelines that come into play here that I'm thinking of around like municipal review, for example. If you want to be aware of any deadlines, for example, an experimental lease has a 30-day comment period. So when we're sending you notice, we're saying, please provide feedback by this deadline. That's something you want to be aware of. Those deadlines don't necessarily apply to standard leases, because like I mentioned, there's no comment period, they automatically go to a hearing. In terms of timeline, when we get to a hearing, there are certain deadlines around when you can apply or request intervenor status. That's always going to be included in the notice. There is timelines around registration, and those again are all included in the notice. Something that you want to be aware of to make sure that you're filing or taking action by those specified timelines. You know, in terms of how long, the question around in terms of how long it should take from start to finish, you know, there is no timeline in rule that I can think of off the top of my head that speaks to that, other than we do have a regulatory requirement that as an agency, I think we are supposed to be issuing a final decision on a standard lease application within 120 days of the hearing. For an experimental, it's a little bit different. I think it's like 60 days after the comment period currently. But we need to change that because we're planning on changing that in rule, because that actually isn't aligned with our process, because we can't actually issue a decision on an experimental until we get the site report. So we probably need to change that to 60 days after the issuance of the site report on an experimental that doesn't need a hearing. We do hit those timelines pretty consistently. It was a little bit different during the pandemic, and also, you know, we've had some staffing transitions. So have we always met that? No, but we do the best we can. It is getting more consistent now. I can't give you a metric on, you know, how long should any of this take. A lot of it depends on many factors that are outside of our control. For example, you know, if a hearing is really controversial and really complex, and there's a lot of exhibits that come in, and it's a really robust record, that would take us more time to get through than say something that is a little bit more straightforward. So yeah, I'm sorry, I don't have a specific timeline on start to finish, but those are some of the timelines that I'm off the top of my head. But yeah, did I answer that okay? Or
Yeah.
Okay.
And then you had a second question about jurisdiction beyond the intertidal zone.
Yeah, and I'll just elaborate on that a little.
Yeah, yep. So like I mentioned, the state's authority to grant leases is exclusive. So that rests with the state. There are some limited exceptions to that, and one of those exceptions would be if a proposed site was in the intertidal, and the municipality had an approved shellfish conservation program, like Chivig does. So, you know, if someone applied for a site in the intertidal, they would need to get the consent from the municipal officers before DMR could grant that site. You know, but like I hope this presentation is conveyed, even though, you know, the intertidal stuff aside, there are a lot of opportunities for a municipality to get involved, and you know, we welcome that and encourage that feedback.
Are there any other? Yeah.
So I don't know if I can actually phrase this in a formal question, but it's more of a statement. I think the reason you're here, requested to be here, is because of the number of leases in the town of Chivig waters. A lot of them coming in from outside, you know, non-residents of town of Chivig. And the reason why we have so many leases in the town of Chivig waters is because of the closure, you know, towards Portland from here, due to the Portland sewage treatment plant. That closure takes up parts of Falmouth, Portland, South Portland, Long, Cape, and all the islands are part of the town of Portland, city of Portland, but it takes up a huge area that would probably not be bad water quality if it was tested on a regular basis or whatever, which, I mean, it's crazy that it didn't start 5 years ago, but why can't, I guess I will phrase this in a question, why can't those waters be opened up? And that would spread out the whole aquaculture in Casco Bay.
Yeah. Well, I'm really glad Cole's here. She can certainly speak to that.
Yeah, I think that's when a lot of these prohibited areas around this sort of treatment plant outfalls were determined in like the early 2000s. Aquaculture wasn't as active and growing as it is now. And so some of the lines that were created, there were dilution calculations that were done, but also, ease of enforcement was considered. And, a lot of the focus was on intertidal shellfish harvesting, basically the soft shell clams. And so people really didn't consider aquaculture usage. And so these big areas were created, and now to undo them, you need a lot of supporting information and data, like hydrographic modeling and things like that, to prove you can pull back those lines. So it's unfortunate that they were sort of arbitrarily big when they were created in the early 2000s, because pulling them back, there's quite a burden to pull them back. There is a group of us working on that actively. We've engaged the University of Maine in doing hydrographic modeling on wastewater treatment plants, so we can try to reduce those areas because of the interest primarily in aquaculture. But it's a really good comment, and certainly something that we're working on actively. Yeah.
Great. Well, I'm glad to see you're working on it. Hopefully it, goes, hopefully it's a fairly quick process.
Yeah.
Open those up. Thank you.
Could I just say that Tom Long Island is enjoying not having too many agricultural leases in their town waters because of the pollution aspect of it. And they can just come over here to Sheboygan and take up our town waters with agricultural leases. And also, one other question in regards to, probably you could answer it better, in regards to pollution. I was once told by DMR, one of the DMR water quality experts, that the cove down here at Stone Theater Creeks, there are 100 gulls. I'm on the shellfish, so I know a little bit. 100 sea ducks in that cove overnight. If you tested the water that next morning, you could it could defecate in that cove. It could shut that cove down for digging clams because of pollution from the sea ducks. Every single oyster site that I see has strung right out with oyster boxes, and every single one of them has got at least 3 shags. And every time you go by one of those oyster box lease sites, floating boxes, every time you go by, they fly. And the first thing they do when they fly is eject. And it goes on the oyster boxes. And people are eating those oysters out of those oyster boxes that are, my way of thinking, not fit to eat. Why would 100 sea ducks in the cove shut a cove off to clam? But 100 shags sitting on oyster boxes every day. They sit there all the time, drying their wings. Every time you go by, they defecate on those oysters. Why aren't they required to test every time they harvest oysters from those oyster boxes, floating boxes? I know some guys. One of the guys I know that has oysters. He grows his oysters on logs, so that's not a problem. So there's an awful lot of things about what's going on with aquaculture in regards to, and in effect, it has an effect on other fisheries that DMR, and when you go to a public hearing on any of these discussions about changing rules, or you explain to people who don't have a clue about what we do out there in the water. DMR is supposed to know. They don't have a clue what we do out there in the water. And yet, because money is involved, and because the state wants to promote this industry, this growing industry, agriculture, because the state wants to promote it, nobody listens. We don't get anywhere. I've gone back and tell you how many of those goddamn hearings down in Augusta. I've spent time, taking time away from work to protect what I consider my rights and my livelihood out there in the water. And I'm tired of it. And hopefully I am gonna take my own advice and shut my mouth and let the young people make their own mistakes.
Do any of you have a comment related to the shag and eider
Yeah,
one
and
in
I
public health?
Yeah, I didn't speak to bird species. It's a problem wherever it's happening, if it's happening in a cove or happening in a oyster farm. And there is a question for aquaculturists to provide operations plans that show how they're gonna mitigate for waterfowl that are potentially defecating on the cages. So they either, and this has become a growing concern as aquaculture has changed from bottom culture to more floating culture and things that birds will roost on. So they have to deter them by either physical deterrence or sink their oysters for a period of time before they are selling them for harvest, things like that. So it is being considered in aquaculture, but it goes back to the same point of the prohibited areas that this state and the water quality program and the shellfish sanitation program was designed essentially around the soft shell clam industry, decades ago. And so it's adjusting for aquaculture being an important part of the shellfish industry in Maine, but it's an adjustment, but it is definitely being considered.
Thank you, Cole. We're nearing 7:30, so I just want to check if anyone has any more questions or comments. Yeah.
Carol White, and I guess I just wanted to say, I think it's quite a burden on this community to respond to these aquaculture leases. And the point that someone made when it's cited in a certain community, but encompasses our town waters, it's not an easy process to participate. If the hearings are on the mainland or out here, and we're not necessarily getting notified in the same way. It takes a lot of diligence by our coastal waters committee, which they try to pay attention to the notices that come through. But I worry about that. I worry about the fact that, the shellfish, soft shell clam harvesting is not a huge activity here. And if some of these, like the intertidal situation is tied to maintaining a shellfish committee, I don't necessarily think that's a good strategy if we don't have an active shellfish or, soft shell clam fishery here. So maybe there should be some consideration of just making it the default. And then the last thing I guess I want to say is there are some states where local communities have more influence or input or even regulatory authority over, the agriculture process. And we have a number of people that in the community that are involved in agriculture, and I think the community in general supports it. But I feel like the onus is on us to react rather than trying to plan for agriculture activities. And it would be great if we had a system like the state of Washington where communities develop plans where they can say these areas are good for agriculture, these areas are not suitable for agriculture because maybe Alex is scalding there. And I think there should be some opportunity for communities to have input into a more comprehensive process of planning and not always just reacting to individual pieces. It's challenging time-wise, and it doesn't seem like a good way to manage the resource. Some states have statewide, systems where they've gone through and identified optimal areas for agriculture. The state of Maine hasn't done that. So I think, personally, there should be an opportunity to have a better, thought process about where to site agriculture and where, and partly for our communities and many other coastal communities, what are the areas that we think are most important to preserve the fisheries? What are the areas that we have active scalloping going on that really, might not be compatible with agricultural leases? We had a proposal a few years ago for 200-acre leases near Shebig that were pretty concerning. And I think that's the other thing is that a lot of these small scale farms are not a huge concern, but large-scale farms could really change the character of the community, and similar to sort of the big box store, you know, on the terrestrial side, I think that maybe should have a different regulatory process than a 4-acre lease or an 8-acre lease. So those are just my thoughts. And Dan, I agree that it's a political legislative process, but DMR can change its own regulations, listening to community input.
I just want to underscore what Carol said. I'm not a mariner or a fisherman, and I swim in these waters. I just want to sort of give you a perspective from somebody who doesn't come from the Marine, who served as a selectman for 10 years and dealt with some of these things. And the process seems very myopic. And as Carol pointed out, it's one little lease at a time without any context of planning. What it feels like from where I sat for that period of time is that anything could happen. How many leases are enough around Shabik? As a selectman, I have no sense about what DMR thinks is enough leases or too many leases. And what is it being driven by? And how do we protect, you know, the people who depend on the resources here, and how do we share those resources? There seems to be no plan to share the resource or to lessen the burden. And maybe you need to slow down on giving these leases out in an area like this until you deal with the problems of why they're here and why we're getting maybe more than our fair share and why we can't spread it out. We don't have any control over that, but it affects our people, it affects our waters, it affects us, and it affects our as Carol points out, the burden of the municipal officers to take on these things in a defensive role, you know, time after time.
Thank you. All right. It's around 7:30. Last comments before we move to kind of wrap it up. You guys need to tell us how quickly we need to get out for the fair. Or we're spending the night with you all.
I noticed I didn't get any takers on my invitation. Well, I sincerely mean that. I would take any one of you or all of you and show you 5 different places that I used to and fished for a long time. 17, what was it?
We should make sure we get your contact information.
I would gladly show you, and I'll show you why I can't fish there.
So just because it looks like folks are approaching being ready to go, and we said we wrap up at 7:30, we'll get your contact info. I just wanted to ask our DMR folks, or maybe Bo, if anyone had any kind of closing thoughts. I will just say from myself that I really, from our perspective at the University of Maine Sea Grant, not the regulatory agency, but working in partnership with the regulatory agency. Thanks for all these comments. Annie's been capturing them, and we're going to make sure that they get shared with the DMR, who's been sitting here listening to them anyways. And I know that you guys are recording, so we'll have access to that as well. Really great comments that are connected. I think not just to your experience here on Shabik, but a lot of the comments are sort of representative of some of the concerns that folks up and down the coast have been sharing. So I really appreciate you taking the time tonight to come in and share your thoughts and ask your really thoughtful questions and share your experiences. Anyone want to share any?
No, just in closing, thank you all for coming out and providing us with an opportunity to provide clarification around the different ways that a municipality can get involved in the process. And also thank you for sharing some of those considerations that you've been giving thought to around aquaculture in Shabik waters.
So closing, I'd like to thank Maine Sea Grant and DMR for showing up and answering some questions and in the process. And then obviously the community that joined us here and online, thank you. All right, have a good night.
Thank you.
Thanks.
Attorney, right? Okay, so I'm gonna grab your contact